we'll see. So my grandma and Jill's mom at the same place. So we were at that big courtyard garden. So
into the waiting room?
No, I've just checked it.
Okay. So good morning, everyone. My name is Brittany Cartwright with the Palm Beach North Chamber of Commerce, and thank you all for joining us for today's webinar with Elder and Estate Planning Attorneys, PA. A couple of housekeeping items. I'm sure you might be able to hear background noise at some point, so just keep that in mind. We are going to be muting your microphones so that the seminar can go on without any disturbances. So what I'd like you all to do is, if you have any questions at any point, you can actually scroll over your screen right now and click on the icon that says chat, and then type in your question there at any time, and we're going to go through those towards the end of the conversation when Anné has finished and allowed us an opportunity to ask those questions. Now on to our speaker for the day. Anné Desormier-Cartwright has practiced law since 1980. She is managing partner of Elder and Estate Planning Attorneys, PA, since 2005. Her law practice includes estate planning, probate, and trust administration, planning for long-term care benefits, such as Medicaid and veterans pensions benefits, and probate and trust litigation. And she has lived in Palm Beach County since 1983. So with that, no further ado, take it away.
Great. Thank you, Brittany, and thank you to the Chamber for the opportunity to provide this webinar to talk about estate planning is an act of love. I'm going to share a story with you about my dad. I'm the fourth of 5 children, and in 1964, before the last sibling was born, my dad set up a revocable trust, which means he had total control over it. That revocable trust, he funded a piece of property, a real property that was generating income for him. And he had total control over that income and that asset always during his lifetime. But the goal was to protect my mother and the 4 kids if my dad died prematurely. Fast forward to 2000, my parents and I bought a home together in Florida, and we moved in together. 5 years later, my dad was very ill. And although he had been running the trust for all that period of time, there was a short period of his life that he was not able to function. He wasn't able to sign checks. He didn't want to. He just wanted to get better. So what ended up happening is I took over as the successor trustee of that trust and was able to pay his bills. Mom got the money that she needed, and so forth and so on. When my dad passed away in 2006, that trust continued to pay the income to my mother for her care and her needs. Eventually, my mother ended up in an assisted living facility where she is now receiving the benefits of the income of that trust. When my dad passed, we all knew that my mom was going to be taken care of. She did not need to worry about income. She did not need to worry about cost of care for her care because she knew she had the income from this trust. When my dad died, everything that had been put in place functioned well. The trust continued to work. My mom had access to money. We had access to pay for his funeral costs, and everything was, it happened with a sigh of relief knowing that my dad lived, planned, and left a legacy. So that's the topic of my talk today: live, plan, legacy. And that story hopefully demonstrated that estate planning truly is an act of love, because when you pass away, and it will happen whether it's now, tomorrow, or 10 years from now or more, it's going to happen. So planning and giving to your family that peace of mind, I believe, will help them grieve properly and then be able to function without having to run to an attorney to get advice, get access to money, and the like. So what is an estate plan? Simply put, an estate plan is you determine what you own: a bicycle, a bank account, a car. And then you decide who do you want that property to go to? Where do you want your bicycle to go to? I have a lot of 18 and 20-year-olds going off to college. They're children of my clients who say, I don't have an estate. And I look at them and I go, you own an iPad, you own all of this technical equipment. Where do you want that to go? If you have a plan, if you wanted to give it to your sister versus your parents, you need to put that in writing, for example. And then decide who you want to help you during your life. So they're called your fiduciaries. And these are people that help you when you cannot help yourselves. And we're going to go through examples of that as we go along. So you decide what you own, decide where you want it to go, and write this all down so that you have at least a list of things. And depending whether it's real property or personal property it determines how it's handled. So now the next step is you create a plan of action. And that plan of action includes preparing the documents we're going to talk about in just a few minutes. Those documents, you can do all of them, you can do some of them. If you don't do all of them, I'm going to tell you some consequences of not doing all of them, like a will or a trust, because then it's governed by state law. We're going to go through some examples of that. And then my suggestion is that you review your plan every year to make sure that wherever your property is going, that's where you still want it to go. The opportunity then presents itself, I usually say at tax time, because I'm also going to suggest that you look at your beneficiaries of the bank accounts and the like, and you're usually doing that around tax time. You're dealing with your bank accounts and your brokerage accounts and the like. You want to make sure that those beneficiary identifications are up to what you want them to be. And then you also make sure that you identify those named individuals are still available to serve. In other words, they're healthy, they're emotionally well, and they're still willing to serve when you cannot. And obviously they haven't passed. So what are the documents that you need to consider? There's a whole host, and I'm going to go through them. So the last will and testament is something that is a document effective only at death. And that means that an asset that you have identified with named beneficiaries, the beneficiary will receive that asset with just a few things that they have to do. They have to provide a death certificate. They may have to fill out a claim form. But by operation of law, those named beneficiaries receive that asset. So for example, you name a beneficiary of a bank account owned by one person. That beneficiary at your death is entitled to those assets directly, don't have to go through any kind of court proceeding or the like. With a joint account at a bank, the joint owner then receives that asset. So they then totally control that asset, and they are then the owner and receive those assets. A will is effective only at death. So it provides no lifetime planning. So again, I'm reminding you to check with your bank every year to make sure your beneficiaries are correct. When banks change names and are bought out and the like, I suggest that you always ask for a copy of the beneficiary designation from that bank account in writing with a piece of paper so that you see it. Some banks, and hopefully they've rectified this since the last time I checked, only had places for 2 beneficiaries, and maybe you have 3 kids. So that's something that you want to consider. And then what happens is if you designate percentages, then you have to address that every year. Whereas if you just designate, my 3 children are going to receive this bank account upon my death, if one of them passes, all that has to be done with the bank is to provide a death certificate of that 3rd child or that 3rd person, and then the other 2 inherit everything. If you do it by percentages, however, that 3rd percentage, unless there's a some kind of contingency in that bank account beneficiary designation, then that's going to have to go through your will. A revocable living trust, that's the one I talked about that my dad had. He had total control of it during his lifetime, and he used it for his disability when he was ill. So the income from that trust and the assets inside that trust were being used for him and his dependent, which at the time was my mom, because all of his children were of adult age. And it's a document that sort of acts like a corporation, because it exists even if you are not driving that corporation. You control the assets, and always, and at your death, that trust becomes irrevocable, which means you can't be changed. An example is brokerage accounts are often held in a trust account, so for easy transition during lifetime and then at death. What a trust, or a revocable trust, avoids is having to probate assets to transfer them to the beneficiary, and therefore there's immediate access to that asset. You don't have to wait for the personal representative in a will to be appointed to gain access to a bank account and to basically marshal all those assets. Your beneficiary of your trust is usually named the successor trustee of, and then the name of your trust and the date of your trust. Therefore, you can have it where the trust asset actually owns the asset, or you can name that the beneficiary of a bank account or the like is your successor trustee. So there's two ways that the trust then can control assets. Irrevocable trusts. Irrevocable trusts are for specific purposes, and I've named four examples here. So a special needs trust, if I have a child who is receiving SSI benefits, supplemental Social Security income, or Medicaid benefits, they cannot inherit more than $2,000 without the potential voiding of those government benefits. So if you have a relative that you want to benefit through an inheritance, you want to make sure that in your documents, their inheritance is received through a special needs trust. Medicaid asset protection trusts and veterans asset protection trusts are specific trusts designed to preserve your assets so that eventually you can obtain government benefits for long-term care. So a Medicaid asset protection trust and a veterans asset protection trust, both situations, you give up control of those assets in the trust, but the whole goal is in a Medicaid asset protection trust, you wait out 5 years, and then you can apply for Medicaid benefits, and it protects all of those assets that were in that trust. For a Veterans Asset Protection Trust, it's available to wartime veterans. So we're talking about World War II, Korean War, Vietnam War. And they have to be 65 and older, or at least 100% disabled. And now there's a law where you can only you have to wait out 3 years, but the first $130,000 of assets don't count against you. So, and your home doesn't count, a bunch of other things. There's a lot of exceptions to what counts for obtaining these benefits. A domestic asset protection trust is an irrevocable trust designed to protect assets from people suing you down the road. You don't know about them today, but down the road you have the potential for being sued. A lot of doctors do domestic asset protection trusts, and those are designed to where you give up control, but at the same time you have the ability to protect those assets for future beneficiaries. Okay, so documents, this is what a lot of people are talking about today when they don't have access, they can't leave their home, somebody else has to transact financial matters or health decisions for them. So a durable power of attorney addresses financial matters only. And in Florida, it's effective now immediately upon signing. So that means the agent that you identify, you must give them, you must trust them, and they don't necessarily have to know that they're your agent until need be, but whoever it is, spouse, hopefully, and if not, children, hopefully they're trustworthy, because if they're not looking out for your best interest, then you don't want to appoint them. It typically does not control any assets held in a trust, because the trustee is the only one that typically does that. A durable power of attorney is a good way to manage, so someone can manage your business, but you have to specifically identify that in your power of attorney. Otherwise, if you own a corporation and the like, you can put the shares in a trust instead of doing it through a durable power of attorney. Agents and trustees are fiduciaries and are held to a higher standard of care. So they, in fact, must have access then to your records. And when they have access to your records, they must comply with the rules of managing those assets based upon a higher standard. And the higher standard means not your normal everyday. They're held, the transactions that they work with are in fact looked at closely and scrutinized. The whole goal of a durable power of attorney and a trustee is to act in your best interest for your benefit and not work for themselves. In other words, taking money out unless the authority is in that document, then, and you better document that you're doing it for good reasons, because down the road, people can complain that you took it out for your own benefit and not truly for the benefit of the person that owns the assets when you took them out from. So that's a durable power of attorney. Very, very, very strong, very, when I say strong document, it gives that person a lot of power to manage your assets. And a bank and a brokerage account firm does not have to make sure that you're okay with someone coming in with a power of attorney saying, can they do this, unless it's restricted in that power of attorney to ask you, like they need the original or the like. Next is the access to medical records. So a little levity before we go on to medical records, because a lot of us are dealing with loved ones with severe medical conditions right now. So the picture in the bottom of the screen is the receptionist calling out to Mrs. Cranley. You need to sign this HIPAA privacy form before the doctor can take a look at those warts on your stomach. Well, that will never happen in the medical offices that I deal with, because they know HIPAA compliance is a very serious act, a very serious law that they have to comply with. But there are 3 medical documents or documents that you give people giving access to, either the ability to have access to your medical records through a HIPAA release form. It authorizes named individuals access to your medical records. And there should be people that you want to have access to medical records. Not everybody in your family needs access to the medical records, but it should be the people that you trust to be able to deal with that medical information. The medical power of attorney or a healthcare surrogate is designed to make medical decisions only. And although the law allows the medical power of attorney or the healthcare surrogate designation to be a document that's effective immediately upon signing, I typically have the documents I prepare allow it to be effective only when somebody, like a doctor, says you cannot provide informed consent. Now, an easy example of not being able to provide informed consent is when someone is in a coma. Therefore, you cannot communicate. But if you are able to communicate through, blinking of eyes or the like, and able to understand what a medical provider is, the information they are providing you, then the medical power of attorney agent is typically not going to need to make those decisions. The person receiving the medical care can make those decisions themselves. A living will or an advanced care directive, if you lived in Florida long enough, you remember the Terry Schiavo case in the early 2000s, when her situation was she didn't have her desire to be staying on life support in writing. Her parents fought over her wanting to, that they wanted her to live, and her husband, who wanted to either divorce her or let her die, to get married again. She had been in a nursing home for 10 years and didn't have a living will. So the big fight was who has that decision-making power. In your living will, you can designate who makes that decision for you, and you can tell the world you want to be kept alive artificially if there's no hope for you to survive, or you can be, say, I don't want, in other words, I don't want to be given food. I don't want to be given water. If my condition is terminal, I'm never going to recover from this. And you can define in there what it is that you want the document to say. Typically, in my documents, I suggest that people put in there whether they want food and water, because if you don't put that in, a healthcare provider, according to their Hippocratic oath, can force a feeding tube and can force hydration. And all that does is prolong your life. So my documents typically address that. So again, a little levity. My question to you is this your plan? These are three old ladies saying, when I die, I want to be cremated. The middle woman is saying, I want to be buried. And the third one is saying, I drank so much wine, I think maybe I just should be bottled. Again, a little levity, because when I'm dealing with death and dying, I'm dealing with a very difficult subject. So, probate administration. If you've planned correctly, typically you do not need to probate. There are some needs to file documents with the court, and I'm going to go through what those typical situations are. So you need a probate when assets do not go directly to a beneficiary, and therefore there's nobody that's going to receive them through operation of law. You must go through a probate. In the wrongful death category, that is where you have you've died as the result of the negligence of somebody, a car accident, a medical provider, or the like, and your personal representative stands in your shoes to pursue the damages as a result of that wrongful death. There are lots of statutes on when a wrongful death action can be pursued, but at the very least, if you got hurt during your lifetime and filed a personal injury claim through a lawyer, and either you filed it with a court or you started making demands, if the family wants to pursue that personal injury matter, they must do it through a wrongful death action, where the personal representative then is in fact admitted to the court to be appointed, and they then take over that negligence action through the wrongful death case. And then there's an anomaly in the world of real estate, and it's not a probate issue, it's actually a title insurance issue. So creditors have the ability to make claims against your estate for up to 2 years after your death. Your home in the state of Florida, however, is protected from creditors as long as it is devised, which means given to at death, to a heir, which means somebody that's related to you by blood. And there's some other definitions of what blood is, but it basically is a family member. If you give your home to your neighbor, that home is not protected from creditors. So in order to transfer that home to your neighbor, it'd have to go through probate. When your home is given to people related to you, then then those people want to sell the home within 2 years of your death, they have to file an action to ask the court to declare that property your homestead and get an order determining that that home is homestead. That's typically what happens when you have it owned in your own name at your death. Some title companies say when it's owned in trust that that document is not needed because the trust stands as the one that owns it. Again, it depends on the title insurance company. So typically what happens with your passing is if the property is going to be sold within 2 years of death, if the title company requires an order to determine homestead, make sure you know that in advance of trying to buy or sell that property, because it slows down the process of getting the closing to occur. So trust administration during life and at death. So this is where I talked about my dad had the ability to control these assets during his lifetime, and I took over when he wasn't able to. And the income from that trust was used to pay his bills and for his benefit and for my mom. At death, the successor trustee, typically that's a spouse when there's a joint trust, then pays your debts and distributes property accordingly. Sometimes it stays in that trust. Sometimes it's distributed outright to the beneficiaries named in the trust after all the bills are paid. If in fact you want to provide beneficiary creditor and predator protection, and I'll explain what that means, then you want a subtrust inside of your trust. For example, you have a son-in-law that is always making sure that his wife, your daughter, wants to have all the money that you have in your bank account because you're the only one taking care of, the mom, and he's always elbowing the wife, saying, please make sure that you get more than the share from the other two siblings because you're doing everything. Those are what I call predators. So this means that son-in-law is trying to get more share from the trust than you've designed it for. If in fact that son-in-law eventually gets mad at your daughter and divorces her, then if it's in a subtrust, then, and depending on how the trust is designed, the daughter-in-law won't have access to those assets, and therefore the son-in-law won't be able to demand any payments. It's also good protection for those people whose children are physicians and the like, or architects and the like, professionals get sued. The creditors cannot go after that subtrust held in the name for the daughter because it is secured through that document. And again, it all depends on your situation. If you want to give funds outright to your heirs at death, or if you want to preserve those assets for generations to come, other children's children, and the like. So this revocable trust is not an asset protection trust from your creditors. So your assets would be used then to pay your bills at death. Oops. So probate and trust disputes after death. So if you have minor children and you are married, your spouse, the parent of that, assuming it's the parent of that child, is going to be able to take care of them and obviously manage the affairs for that minor child. However, if you are divorced and you have a minor child, the natural parent automatically, according to the statute, has the right to live with that child, has the right to take care of that child. So if in fact any assets are inherited, then through whatever mechanism they're inherited, then the parent of that minor child may have control of those assets. So that is specialized planning that needs to be incorporated into your plan. One way to address this is to identify a guardian for the minor child. If it is not the parent of the child, you may, when you pass away, you may have issues with the court, but at least you've tried to do something to help that designation be effective in court. And then second marriages. Second marriages raise the issue of whoever dies first, depending on your plan, gets control of all the assets and therefore can decide not to provide to your children or your heirs or your charities or the people you want to benefit from your legacy and lifetime of planning and saving. So you want to get that addressed. Do you want the trust that you've created to be irrevocable at death, and therefore whatever's designated is set? And so the surviving spouse doesn't have the ability to control. Do you want separate trust where your assets are then divided, and some of them in your trust, some of them in your second spouse's trust? Therefore, they don't have control of those assets when you pass. You also want to think about business concerns. And the question that always comes up is, who owns your website at death? Who runs your business at death? These are things that can be addressed through estate planning documents to be effective during disability, and more so at death, because you want to make sure people have those ones that you want to have control over, to have control over these things. And then, of course, who has access to all the bank accounts, websites, social media, and other password protected items? What is your plan to address that? Do they have the ability to access this? And a lot of times you have to go through whoever's the provider, but there is a Digital Asset Act in the state of Florida that can address those things if they're properly addressed in your documents. And then the other thing is, if you, with planning needs for spousal rights in the state of Florida, we have a law called elective share, which means you cannot inherit a spouse without a prenup or a postnup. And that means at death, they can elect against your will and your trust up to 30% of the value, and the assets that are included in the definition of what is owned by you at death is huge. It even includes the death benefit in a life insurance policy. So if instead of designating your spouse as your beneficiary under a life insurance policy, you designate your child, and that spouse feels aggrieved, they could elect to and file a spousal election suit to force that beneficiary of the life insurance policy to pay over some funds. So planning is necessary if you're going to attempt to disinherit a spouse. Just 1 second. Okay. Okay, so 5 tips for your estate plan. I suggested to you that you check your beneficiaries annually, and I suggest that you do this around tax time, because that's usually when you're dealing with the 1099 information that you're getting from your banks and that you're getting from your brokerages. That's the best way to remember when to do it. I suggest that you ask for these beneficiary designations that are get them in writing, and confirm that's what you want. Confirm when you look at this, you're going to say, yes, this is who I want to receive this asset when I pass, and it's only beneficiaries are only effective at death. And you want to make sure that all of those are named accordingly, and that you understand what happens if one of the named beneficiaries passes. Where does their share go? I also suggest that whatever documents you have in place, that you check your agents, your power of attorney agent, your medical power of attorney agent, whoever is going to execute these decisions for you when you're not able to. Make sure they're healthy, make sure they're well, make sure they're going to have access to information. If they're a medical decision maker, you want to make sure that they have access to your medical information through a HIPAA release form. Your relative that's going to make these decisions for you may be out of state. And so if you haven't designated to your doctor that that person can receive the information, a HIPAA form is typically universal, so it can be given to a doctor wherever. Let's say you're traveling, although right now I know we're not, but when we're able to, when you're traveling, that HIPAA release form is a great tool to be able to give your family members access if you get in a car accident or you hurt over in Arizona, or a state that you don't have a doctor in. This is a great way to be able to give your family access. I had a situation where a friend of mine's child was 19. He got hurt in North Carolina at school, and not even the hospital would confirm or deny that that child was in the hospital. So the parent had no access because she wasn't named as a person that could receive medical information. And okay, so this is a little morbid, I get it. Number 3, write your obituary. So I can tell you from experience that when my father passed, my mother was obviously very distraught, 58 years of marriage. And the one thing that I asked her about, because I'm the 4th of 5, I don't know what my dad did in his early 30s and 40s. I was, either not alive or, busy growing up. And the obituary that we had placed in the paper identified a organization he didn't belong to. We said he was president of blah, blah, blah. And my mom was wrong. Eventually we realized it, obviously no need to correct it. But that was something that bothered my mom for a long time. So we talked about it and I said, well, Mom, let's write our obituary so our family doesn't have to. My mother is the last of 12 children of her siblings alive. So nobody else in her family is going to be able to tell the stories that she wants in an obituary. So I suggest you write it, update it every year as things change. The one we wrote for my mom includes all her named brothers and sisters. Again, she knows them. My mother's the 11th of 12. So a lot of these relatives were much older by the time I came along. The next thing I want to talk about is determine your funeral plans. Effective January 1, 2020, any funeral plan you have in writing must be signed and witnessed. That was a change because people were arguing over where the body goes. So any direction that you want to be cremated, you want to be put in an urn, placed here, there, or the other where, anywhere, those funeral plans have to be signed by you and witnessed. And so if you have those documents in place, I suggest that you pull them out and make sure that they are witnessed. And then the other thing I'm going to suggest that you consider is, and I know this is not the greatest topic to talk about in considering what the world is experiencing with COVID-19, but it's a fact of life that your life will end someday. And as difficult as that is to face, when you plan your estate and have documents in place so that things can function as if you were here, the gift that you give your family is peace of mind. That peace of mind is worth much more than the money you have to pay an estate planning attorney to draft documents for you, because they can sigh and breathe easily knowing that you put the dotted the I, crossed the T, and identified everything where you wanted it to go and who it was going to be used for, maybe while you're ill and then at your ultimate death. Those are the 5 tips for your estate plan. Okay. And now I'm going to open it up to questions. Okay, so somebody asked, I have a copy of my parents' living will and durable power of attorney. Can I copy the verbiage and tweak it to fit me? Or do I need to get it notarized, and do I need to go through an attorney? So North Carolina is the example I gave of the state that had no access to the medical records of a child. So I just use that example. So depending on where this durable power of attorney and living will came from, I suggest that you consider going to an attorney instead. The living will is a little bit easier to document because that's actually what you need in a living will is actually in the state statute, okay? But it still needs to be witnessed by 2 people not related to you, and your signature needs to be notarized in a living will. And the signatures of the witnesses need to be notarized in the living will because they need to state that you are not related by blood to any of them. For the durable power of attorney, your signature needs to be notarized and your signature needs to be witnessed. So the document that you need to address in a durable power of attorney is very specific. In the state of Florida, since October of 2011, we've had what are called specific powers, special powers that must be initialed. So using a form that doesn't comport to the statute may lead you without an effective durable power of attorney. I looked at a durable power of attorney the other day that said nothing about suing and defending lawsuits. And I'm not sure why that was left out, but it was left out. So this person that got put into a facility because they're sick, their agent cannot defend the lawsuit, which means it right now, bad things could happen to the person that got sued. The next question, how should a husband and wife title their primary residence in Florida and why? The best way to own real estate in the state of Florida is husband and wife, because it basically means that it goes to the surviving spouse at death and doesn't then address the minor children. If you have a minor child with like a husband and wife has a minor child together, then it's okay that the surviving spouse inherits that home because it doesn't violate the statute. If you have, if you own it as tenants by the entirety, then it's protected from creditors anyway because it's your homestead, and therefore when the one spouse dies, the other spouse inherits it. The other question that came up is, so with a living will, what happens if that document is not enforced by the family? The doctors are supposed to, by statute, enforce that living will. So as long as you provide it to the doctors, if it says, don't give me life-prolonging procedures, and life-prolonging procedures deal with heart and lung issues. So if someone's having a heart attack and you say, no, I'm sorry. The question was about a do not resuscitate order, not a living will. I apologize for that. So with a living will, it doesn't address the DNR. DNR is a do not resuscitate order. That comes from your doctor, and it deals with heart and lung issues only. If you say, I do not want to be resuscitated, then you want to make sure that you go through your doctor to make sure you're consulted. Everybody that signs the DNR, it also must be signed by the physician, and that physician must provide counseling. First, make sure you understand a do not resuscitate order, what it means. It means that no one will give you mouth to mouth, no one will resuscitate you through a machine or give you CPR. That's what a do not resuscitate order. That is different from a living will. A living will is a document that says, if I cannot communicate to the world and I have a terminal condition, don't keep me alive artificially, or do everything you can to keep me alive. So those are the questions that I had on the chat. Are there any others? Okay, next question. Does it make sense for your trust to own your home versus a joint tenants or tenants by entirety? Well, there's a two-prong opinion on this. A series of attorneys believe it's best to own as tenants by the entirety. Others believe it is best to own it in a trust because then the distribution is easy at death. Here's the concern. In the late 90s, two bankruptcy courts in the state of Florida, bankruptcy courts are federal courts, they are not state courts. These federal courts decided that some very bad people that came to Florida trying to take all of their assets and put it into a home to protect it, because there's an unlimited creditor protection for your home in the state of Florida. That protection is afforded to anybody that, a creditor tries to come after your home, can't be sold except to can't be sold, a forced sale, except if you have a mortgage foreclosure with a properly executed mortgage, a lien by a licensed contractor that didn't get paid, or you failed to pay real estate taxes after 3 years. Your property can be sold and you can lose it. But a medical provider that you owe $50,000 to, or a credit card you owe $50,000 to, they can't force the sale of that home to satisfy that debt. That's what's called a homestead creditor protection. In these bankruptcy cases, these bad actors came to Florida, and I think the one case was they bought a $13 million home. So the bankruptcy cases said that was fraud upon the creditor, and therefore holding it in the name of the trust was, they're going to go through that and void that. And that involved a trust. So a lot of attorneys were getting scared about having the trust own the real estate, owning the home. That home is the best, the most secure way is tenants by the entirety to protect it from creditors except for your the three situations, the home improvement, the bank foreclosure, or the real estate taxes. That is the highest way of owning and the best way to own tenants by the entirety. I do, and I know many lawyers that fund homes into their joint trusts, and therefore it's still available to that spouse, that surviving spouse at death, and then can be transferred to the beneficiaries when the final spouse dies. So it really depends if you want to take that risk and understand that there are bankruptcy courts out there that have determined that owning a home in the trust isn't consistent with the way our Constitution reads, and our Constitution reads individual, and a trust is not an individual. So hopefully that answers that question. Okay, do we have any other questions?
Okay, if there are no further questions, then I'd like to thank you, Anné, for helping us during this difficult time understand some available opportunities we have with some estate planning. So without further ado, we will end it here. And if anyone has any questions and wants to reach out to Anné, reach out to myself or anyone at the chamber, and we'll make sure to get you connected. Thank you all and have a wonderful day.
Stay safe, everyone.
Thank you so much for this.
Yes, absolutely.
It was amazing.
Good,
From
thank you.
Jill.
Yes, hey. Mhm.
Okay, guys, have a great day.
Okay, you too. Bye-bye.
Bye.